Yes, my lady, the next witness is Martin Hewitt, who appears on video link. May the witness be affirmed, please.
Good afternoon, Mr. Hewitt. I'm going to take you through the affirmation. Can you hear me okay?
Oops.
No.
No, Mr. Hewitt, can you hear us?
I can now, yes, I can.
We thought you looked a bit adrift. Right, if you listen
Mr.
to the
Hewitt,
ocean.
I'm going to take you through the affirmation. Please can you repeat after me? I do solemnly,
I do solemnly,
sincerely and truly
sincerely and truly
declare and affirm, declare and affirm,
sorry, your voice is very quiet. I can hardly hear you, I'm afraid.
it's declare and affirm
Declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you for joining us again, Mr. Hewitt.
Thank you. Mr. Hewitt, can you hear me?
Did you hear counsel to the inquiry, Ms Nagesh, Mr. Hewitt?
No,
No.
only yourself, Chair, is coming through loud and clear.
I'll try moving. Mr. Hewitt, can you hear me now?
No, it's very, very quiet.
Oops.
That's true. I knew there would be technical difficulties at some point, but Mr. Hewitt, does this work?
No, I'm sorry.
So, unless we can you hear Ms Nagesh? Don't know if RTS can help.
Thank you.
If you could bear with us, Mr. Hewitt, they're going to try
I
and
will.
solve the problem. Don't understand. The green lights on your microphone are on.
It's echoing in the room.
Mr. Hewitt can hear me.
I can, loud and clear.
Can you hear me now, Mr. Hewitt? No. Thanks.
I'm wondering if there's any. Sometimes we've had this people by moving position. That one's not working down the end, is it? I appreciate you're all set up there.
No, I can move if need be.
Just could you just say hello into? Let's turn that one on.
Hello? Hello?
No, not on. I'm just thinking a bit of the difficulty in moving with all the stuff that Nagesha's got.
You just need to be linked into the... I'm told, my lady, they've asked for a 5-minute break to sort out the issues.
I'm sorry about this, Mr. Hewitt. We've had very few problems, I'm delighted to say, with technology, but this afternoon happens to be one of them. So they've asked for a 5-minute break, and we'll try and get back to you as soon as we can.
Okay.
All rise. Let's try again, Miss Nagesh.
Yes, my lady, thank you for the 5 minutes. I believe, Mr. Hewitt, you can hear me now.
I can hear you loud and clear.
Thank you. Thank you very much for bearing with us. You have provided a witness statement to this inquiry. I won't pull it up on the screen, but I believe you have a copy with you.
I do.
And if we look, please, on the, I believe it's the last but one page, that's page 63. We see there, don't we, a statement of truth attesting to the truth of everything in the witness statement and your signature. Is that right?
That's correct.
Is it true that everything in that witness statement remains true as of today?
It does.
It's right also that although you have authored that statement, you've done so on behalf of the National Police Chiefs Council, otherwise known as the NPCC, because you were the chair of the NPCC between 2019 and 2023, is that right?
That's right.
And so that's why you're qualified to talk about not just the role of the NPCC, but the role of policing in general during the pandemic.
That's correct.
Thank you. So you have also provided one previous witness statement to this inquiry for Module 2. And you, in fact, gave live evidence to this inquiry for Module 2. Is that right?
That's correct.
Now, inevitably, there may be some overlap between the matters you talked about then and the matters we'll talk about today. But do please rest assured I don't intend to exhaustively repeat matters you've already told us in detail. So having said that, could we start with your professional background, which we'll go through quite quickly by way of refresher. You'd been a police officer since 1993, I believe, when you joined Kent Police.
That's true.
And you subsequently moved to the Metropolitan Police in 2005.
Correct.
And in fact, whilst in that role, you served as Assistant Commissioner in two spheres, professionalism and frontline policing.
That's right, yes.
Then from 2015 to 2019, you were Vice Chair of the NPCC.
Yeah, that was alongside my full-time role in the Met.
Thank you. And then you were appointed Chair of the NPCC in 2019, and you held that role until April 2023.
That's correct.
Thank you. So if we now move on to talk about what the NPCC is, in fact, it's right that it's a national body which coordinates police forces in the United Kingdom.
That's correct, yeah. For all police forces in England, Wales, Northern Ireland, Scotland, and then non-home office, so the smaller police forces as well, and indeed for police forces that are in overseas territories.
Thank you. All those forces participate in decision-making for the NPCC through a council called the Chief Constables Council.
That's correct, and I would chair that Chief Constables Council meeting.
Thank you. Now, importantly, the NPCC doesn't have powers to direct police forces to do anything. Is that right?
No, all of the forces sign up to be, under the Police Act, sign up to be part of the NPCC, but each Chief Constable or Commissioner, depending on the senior person in that organisation, is entirely legally independent and is responsible for their own particular force.
But the NPCC can offer, I believe, guidance and recommendations to the police forces.
Yes, definitely. It's particularly around policy and strategic issues that affect policing. The role of the NPCC is to bring all of those forces together so that we collectively, as policing, can decide on the direction.
I believe that the Chief Constables have signed an agreement to follow the recommendations of the NPCC, but they do have the power, if they so choose, to derogate from that agreement.
That's correct, yes.
But in practice, is it right that derogation from the agreement is rare?
It is very rare, yes.
And in fact, there was no such derogation from the recommendations of the NPCC during the pandemic?
Not to my recollection at all, no, they weren't.
Now, before we move on to the NPCC's role in the pandemic, there is one more organisation I'd like to touch upon, and that's the College of Policing. Mm-hmm. Is it right that the College of Policing is an organisation separate from the NPCC, which sets standards for police and is responsible for their professional development, such as training and things like that?
Yeah, that's correct. The college has the responsibility, so works into the Home Secretary, but has the responsibility for standard setting, for the provision of guidance to policing, and also learning and development particularly. It's effectively the sort of knowledge centre for policing.
Is it right that the NPCC worked closely with the College of Policing?
Yes, we worked very closely. When I was undertaking the role as chair, the two other key links that I had was with the chief executive of the College of Policing at the time, and also the chief inspector from His Majesty's Inspector of Constabulary and Fire and Rescue, and we would work as a trio in terms of policing leadership.
Now, in terms of the NPCC's role during the pandemic, is it right that it was as follows? When the government issued regulations that included matters relevant to policing, such as the creation of criminal offences, your role was to work with police forces to ensure implementation of those regulations.
That's correct. So when it was clear the pandemic was coming, as we were seeing it move sort of westwards across Europe, I took a gold leadership role in policing to bring together how the police service was going to respond to what was going to be requiring of us policing, but policing in a pandemic context. So that was the responsibility that I took on, and then therefore it was through the NPCC that we were guiding and leading and coordinating the activity from the forces thereafter.
And in fact, you set up, I think, a specific operational response to the pandemic in March 2020. And was that response called Operation Tala?
Yes, so we created Operation Tala. It was clear that we needed to bring together the way that everybody was operating across the UK. And then what happened alongside that was that in each individual police force, they essentially replicated a gold, silver, bronze structure, which is the sort of traditional way of dealing with an operation within policing. They replicated that in their own force context. Many of those they designated as Optala, some forces chose a different name, but we then were able to work at a national level and then feed down so that the same was happening individually in each police force.
And just finally on this topic about the roles of various organisations, I'd just like to ask you about the Independent Ethics Committee. Is it right that was a committee set up specifically during the pandemic to, as the name might suggest, consider ethical issues and advise the NPCC and Operation Tala?
So it was very clear to me when we were setting up the operation, and on the sort of priorities around the operation would be the ones that you would expect in terms of how we could help to preserve life and safety, but also absolutely key for me, recognising that we were about to go into a scenario that was really without precedent in policing in the UK. It was really important that we were going to come out of the other end of the pandemic maintaining public confidence in policing, and that really defined the approach we were taking. Very early on in the operation, it became clear that we were going to have to make decisions around really challenging issues, ethically challenging issues because of the nature of policing in a pandemic. And so we created the Independent Ethics Committee, which we pulled together. It was chaired by David Walker, who was the Bishop of Manchester, with a group of people. And it was really, if you like, the conscience to us as Operation Tala made decisions, particularly difficult decisions. It was a conscience that we could test and ask questions of that group to give us a view, not to make decisions on our behalf, but to be as a sort of a challenge point and a critical friend, if you like.
Now, just about on the NPCC's engagement with the government, please. Again, you've spoken to the inquiry about this in Module 2 at some length. But is it right that, firstly, in normal non-COVID, non-pandemic times, would the NPCC be consulted when there was, for example, the creation of criminal offences?
There would be some consultation for different groups within NPCC that had particular lead areas, but that would be at a relatively early stage as policy was being developed or even legislation being developed. That took on a completely different tempo once the pandemic situation began. So the interaction very directly with the Home Office was intense, and the teams working for me were pretty much always alongside the equivalent teams of officials in the Home Office as things were developed, and we were trying to make sure that we were up to speed with how things were changing. And then I was also very kind of closely engaged with both the Home Secretary and the Policing Minister in a very regular pattern as we were collectively trying to provide advice on the policing implications for whatever the government was choosing to do.
And what stage would that be? Would that be before legislation was enacted, or would it generally be afterwards?
Generally speaking, we would find out that there was a new provision, a new regulation. This particularly once we started to get into all the regulations, that process would take place within government, and we would, because of our links, we would generally have some understanding of what was being proposed, and we may get an opportunity to give a bit of an input of what the policing implications of such a measure would be. But it became one of the challenges for us throughout the pandemic that quite often the new regulation signed off by the Secretary of State in the Department of Health would land on us, and it was then a matter for us to try and then subsequently work out how best to advise policing to deal with that particular piece of legislation.
Was there any similar engagement with the Welsh Government?
The Welsh forces, so the way that we operated, I would do the work that I did through Optala with all forces, and all forces were part of the rhythm of meetings and information sharing that I led through Operation Tala. But then what would happen, obviously, in Scotland, Police Scotland would be linking directly with the government in Scotland, similarly with the Assembly in Northern Ireland. And in Wales, because policing is not devolved in Wales, it still comes under the Home Secretary. But the Chief Constables, the 4 Chief Constables in Wales, who work very collectively in that region, would clearly be linking directly into the Welsh Government. And one of the challenges, in fact, that we had when we were putting our operational briefings out, which we would put out every time there was a new regulation or a change to a regulation, one of the things that delayed us was that we had all of those guidance or operation briefing documents translated into Welsh so that they were able to be used in that country.
You bring me nicely onto the next topic I wanted to ask you about, which was in relation to operational briefings and guidance. So firstly, on operational briefings, could you just explain what exactly those were?
So, and I'm sure we'll come on to the one piece of guidance that we issued was the approach that we wanted, the 4Es approach, and I'm sure we'll talk about that. But the operational briefings was really the mechanism by which we were able to share information to all the police forces in relation to a new regulation, a change to a regulation, any changes that took place that allowed that to be filtered down disseminated through the forces so that the officers on the ground were able to do their role in the way that we wanted them to do, because there was quite clearly a role for policing in trying to explain to members of the public what the new regulations were and how that new regulation might affect them. Because, because for me, I saw that as a really clear role. And as we set the strategy at the beginning, we were setting a strategy that was a consensus rather than a compliance strategy. We wanted to work with the public in the way that we try and do in policing to get the public to understand and then to follow the regulations, rather than it being more of a compliance type regime, which we had seen, and I'd witnessed that as the pandemic had moved through Europe. I'd witnessed the sort of styles of policing that were happening there, and I was really determined that we weren't going to adopt that in this country.
Thank you. How were the operational briefings disseminated? Was it in the form of
in a number
training?
of ways. They would be issued whenever they were complete. They would be issued to all forces. We used a whole range of different means of communicating. The whole purpose of the operational briefings was to make them very straightforward for the individual officer on the ground, who was going to have to understand this and then translate that into how he or she was going to act in accordance with the law. We used infographics. We used a whole range, which we have shared with the inquiry previously, to really try and make it as useful a tool for the individual officers who were the ones that were having to face the decisions about what action they did or didn't take.
Now, you mentioned guidance. It's right, I think you've just mentioned that you only issued one piece of guidance during the pandemic.
That's correct.
And if we can get that on screen now, please, INQ 999, oh, there it is. Can you see that guidance?
Yes, it's just come up, yeah.
And that's guidance on applying the 4Es, as we can see at the top. and we'll come on to talk about what the 4Es are in just a moment. I first just want to ask you a few questions about the guidance itself, please. First, there isn't a date on it. Do you recall when this guidance was issued?
It was very early on. I mean, it was in March of 2020 that we worked through very quickly to try and provide that guidance. And I guess the important point is to make that it didn't change throughout the policing of the pandemic. It remained as it was, and it was the only guidance document that policing issued during the pandemic.
Mentioning that it hasn't changed, if we look at the bottom right-hand corner, the final bullet point that starts, police can issue a fixed penalty notice of £100.
Yeah.
We will hear, I suspect, later that the fixed penalty notices, I believe the fines changed.
Yes.
Was the guidance updated at all to reflect the changes in the fine levels?
I'm pretty sure the guidance would have been updated to reflect that. Sorry, I guess the point I was making was the concept of the 4E approach didn't change throughout, but I can't say for certain, but I would be very sure that would change as the levels change, which, as you know, they did a number of times and in the different countries.
And just in relation to the different countries, I can see at the top right-hand corner of the guidance, I think you've anticipated, there's an English flag. Does that indicate this guidance was just disseminated in England, or was it in fact disseminated across the 4 nations?
It was shared with all 4 nations. Clearly, Wales would have translated that into Welsh as well as English. And the 4Es guidance was shared with Police Scotland and with the Police Service of Northern Ireland. Now, they didn't formally, they kind of operated to that principle, but they didn't formally, if you like, adopt it as guidance, because they clearly were also working with what was coming from their respective administrations.
Did you at all assess the effectiveness of the guidance? Did you seek feedback or anything like that?
We constantly did, and we were constantly sort of challenging ourselves as to whether the way we were operating was how we needed to operate. And clearly, once we started being into the regime where fixed penalty notices were being given out, then we were monitoring and looking at the changes around there, because clearly, in the guidance terms, the point where you've used a fixed penalty notice is at the enforced point. So it was really just trying to assess, and we were doing that continually throughout the process to satisfy ourselves. And then individually, obviously, forces were looking at the performance within their own force area to try and understand whether that was demonstrating that the 4Es model. But I am very confident, having been through the whole process, that the 4Es was adopted very strongly as the means of us operating, but it always was facing the challenges as the situation shifted and regulations shifted, and the sort of the tone and the atmosphere in the country shifted in the various phases going through the pandemic.
And so I would like to ask you about the 4Es and what exactly they were. We can see at the top, perhaps an explanation: engage, explain, encourage, enforce. So could you please explain what the 4Es were?
The whole purpose of the 4Es was the point that I've made about this wanting to be how we can use a consensual model rather than a compliance model. And everybody, it was very clear from the outset, there was going to be challenges with people understanding what the regulations meant for them, understanding what had changed. So the whole concept was, and this is how you try and apply policing in a general sense. So the first thing is about engaging with people. So this is not a kind of robotic policing enforcement issue. We are here to provide policing services in the context of a pandemic. So engage with the people that you are coming across. The explanation point was really important, because we recognise that the average member of the public would be getting information from here, there and everywhere, which often in the media was not accurate. And so we, by producing our operational guidance, our operational updates, briefings, were allowing the officers to understand precisely what that meant, and we were explaining that in very plain English. So your role is to explain that to the person and then encourage them to comply if there is a requirement for them to comply, because the whole purpose was to avoid getting to the point where what you had to do was enforce, which could either be arrest or it more prominently became fixed penalty notices. We wanted that to be the last point that you went to only when the other three, or certainly the second and the third element had gone through before you got to the point where you were then doing something which had a potential sanction on the individual. Because again, our whole approach was not about trying to deal with criminality per se. It was about how do you allow and help people to abide by the regulations that are there to avoid, spread of the pandemic.
So, as enforcement was a last resort, does it follow that there were cases which were dealt with without the need for enforcement?
Oh, very many would be my argument. And unfortunately, and I recall this from when I gave evidence in Module 2, it was unfortunately impossible for us to be able to. You can measure when a fixed penalty notice was issued, you can measure if someone was arrested. It was impossible, and it would have been a wasteful process to try, because there will have been thousands and thousands of engagements between police officers and members of the public at the various stages as the pandemic progressed. And in the vast majority of those cases, my belief would be that we got to the point of encourage, and that was all that happened. But clearly, there were a number where there was a requirement to enforce, where people were blatantly refusing to abide by the regulations.
And so we'll move on to that enforcement side of things now. And thank you. We can take that guidance off the screen. There were effectively two ways in which officers could enforce an offence, weren't there? First, fixed penalty notices, and secondly, charging an offence for court proceedings. So I'd like to talk with you first about the process of fixed penalty notices and the court process, just so that we understand the background. So in a nutshell, a fixed penalty notice is what we might colloquially call an on-the-spot fine. Is that right?
Well, it's when you're effectively giving someone that notice of an intention to prosecute. It's a bit like you get the speeding ticket comes through the post, where there is obviously ultimately a potential that could go to court, but you are essentially being offered an option to deal with the process by paying a fine within a particular period of time that then obviously saves the need for the process to work the way through to the court.
And so, therefore, it's not a criminal conviction.
Correct.
So, in practice, if I understand this correctly, what would happen during the pandemic if an officer saw someone or knew somebody was committing a COVID-related offence? Assuming we get past the first 3 E's and move to enforcement, the officer would inform the person that they'll be subject to a fixed penalty notice. Is that right?
Yes.
The officer then, I believe, fills in a pro forma with the relevant details about the offence and the offender. And that pro forma is sent to a central organisation called ACRO, Criminal Records Office. ACRO is a central organisation separate from the police
It is.
and the NPCC. ACRO would then review the pro forma, and if all was in order, would issue the formal notification to the respondent. If there were any problems with that form, they would return the matter to the police force. Mm-hmm. Just pausing on ACRO briefly, did they deal with fines for all 4 nations, or was it just England? Or
ACRO's normal role is managing criminal records and the exchange of criminal records. It very quickly became clear that there was going to be a real challenge. We needed to centrally find a place to manage the fixed penalty notices, which were the pro formas were done differently in different forces. So the process would be the officer would issue the fixed penalty notice. That would be looked at in their force, where they would do some checks. We then got to a position fairly quickly where ACRO were the ones that were bringing this all together, and they would do further checks. And as you say, if there were issues, they would send it back to the force. That was definitely with England. We originally started it with the force that hosts ACRO, which is Hampshire Police. But then we realised this would make sense to bring it all in one place. Wales came on board eventually, along with some of the other smaller forces. And I think Northern Ireland, my recollection, I think, is that Northern Ireland stayed separate, but Scotland started to use that facility as well. But this was not a mandatory process for the police forces, but it was a way that we were able, at the centre, collectively, to bring things together and understand that we had at least a consistent process that was being applied to all of the issues.
Do you know when ACRO's role expanded to cover the Welsh forces?
I don't, off the top of my head. I don't know whether it might be in the statement. I can't recall off the top of my head, but I don't know the answer to that question.
Going back then to the process of the fixed penalty notice, once ACRO has sent the fixed penalty notice to the respondent, that person then had two options, didn't they? They could either pay the fine, and that would be the end of the matter.
Yeah.
Or they could not pay the fine, and the matter would then go to court.
Yes.
Via the police again, who would charge it. So if a person wanted to contest a fixed penalty notice, they could simply refuse to pay and go to court. Was that one way of doing?
That was one way of doing it, yes, that would be the one way.
And another way of a person contesting a fixed penalty notice would be to go directly to the police force before they'd sent the form to ACRO. Was that an option?
Potentially. I think that would be, I'm not sure how that would have worked. They would obviously know that they've been issued with a fixed penalty notice, but I'm not aware. And that clearly would have been a matter that the individual forces would have to deal with.
So turning then to what happened when the matter would go to court. Now, it's right that in most normal, if I can put it that way, non-COVID-19 offences, when a criminal charge goes to court, it's prosecuted by the Crown Prosecution Service in a public hearing before a judge or a bench of magistrates, and the defendant would appear in person. That's the usual process, isn't it? Mm-hmm. But in relation to COVID-19 offences, I believe a different procedure was adopted called the single justice procedure. Is that correct? Now, the single justice procedure was a mechanism available to courts since 2015, I think. But it was widely used for the prosecution of COVID-19 offences. Is that right?
I believe, yes. It was certainly one that became one of the ways that things were dealt with. Yes.
And what it meant effectively was that a single magistrate would look at the offence paperwork, and the defendant wouldn't need to go to court, and nor would lawyers. But the defendant could submit written representations. Yeah, I mean that is the single justice procedure process. But I mean, clearly that is really more of an issue, I think, for HMCTS and those processes. I think one of the factors that was at play clearly during the pandemic was pretty much at the outset of the pandemic, the courts were closed down. And so, and we had started the pandemic in a situation where there were quite considerable backlogs in, both in magistrates and Crown courts. So I can understand the logic of trying to speed up that process, but it clearly has its limitations. But for those proceedings, police were, I think, designated by the Attorney General to be prosecutors rather than the Crown Prosecution Service. Is that right?
That's correct, yeah. And that would have been done individually within the forces, yes.
Were you, as the NPCC, consulted at all in relation to whether the single justice procedure should be used?
I wouldn't probably describe it as consulted. I mean, through our criminal justice, so the way the NPCC operates is you have a number of portfolios headed by an individual chief constable. Our criminal justice portfolio were very involved throughout the process as ideas like this, or how we were dealing with the fixed penalties, how we were managing the fixed penalty, they would have been directly involved in those discussions. Whether that was consulted in the sense of being able to change the decision, I wasn't party to any of those, but we would have definitely been part of the discussions that in advance. I think it would be fair to say.
Thank you. Now, if we turn back to the fixed penalty notices themselves and the amounts a person might be fined, which we touched on earlier, if on screen, please, we could have 587307, page 50. Thank you. Yes. I think you can see there a table which you've helpfully set out in your witness statement.
Yes.
This represents the fine levels as at 26th of March 2020. Is that correct?
If that's what it says in the, yeah, I believe so.
And we can see at this stage, England, Wales, Scotland and Northern Ireland all had a minimum fine of £60, reduced to £30 if paid in 14 days. Mm-hmm. And then the final column is headed further penalties. That refers to repeat offenders, doesn't it?
Yes, it does, yeah.
And so if a person's given a fine a second or third time, each time they're given a fine, it's the amount doubles.
Yes.
Now, in England, Scotland and Northern Ireland, we can see that the maximum level of fine was £960, but in Wales it was £120. Do you know, you may not, and if so, please say, why Wales had a different maximum fine?
I don't know the answer to that. I think it's fair to say, from my perspective, so this is from a policing perspective, the way that all the forces across the UK work together, I think was pretty effective in terms of us being able to approach things in the same way. What was happening politically clearly were differences. There were occasions where I was involved in cabinet meetings or government meetings in relation to how things were changing, where you would have the devolved administrations were present in those meetings online, and you could see that there were differences of view in terms of particularly around fines. Now, these clearly were not a police matter to decide on the levels of fines and how that would move forward, but it certainly did become quite an issue for us, and there were periods with some of the different regulations where some very significant fines were being considered. And of course, the reality for that from a policing perspective is it's a police officer ultimately that is engaging with the individual. So that, I think, led to some real challenges as the fines were considerably higher. But why the difference between Wales in that particular set would have to be something that you'd need to ask to the administration there.
Well, you mentioned fines becoming progressively higher, and is it right that in May 2020, the minimum fine in England, and if it assists, this is at your paragraph 142, we don't need it on screen, but I think you have it in front of you. In May 2020, the minimum fine in England increased to £100, and the upper limit, the maximum, increased to £3,200.
Yeah.
And then in September of 2020, the minimum fine that could be given to somebody breaching a COVID offence increased to £200, with a maximum of £6,400. Mm-hmm. But in Wales, the minimum remained at £60, but in May 2020, the maximum increased to £1,960, so somewhat less than the maximum in England. And in Scotland, the maximum fine was actually reduced to £480. What difficulties, if any, were caused to the police force officers in enforcing offences with different fine values?
I think it was another layer of the challenges that police officers had to face, because clearly this kind of information was being publicised, and you can see there my perception at the time was as infection levels were rising, there would be more pressure from the government to be seen to be taking stronger action. And one of the mechanisms that repeatedly, as you've just read through in that point 142, was just a continual racking up it's interesting, that last sentence, because clearly in Scotland, the legal establishment then obviously became part of that particular discussion. From a police officer point of view, it was never our responsibility we had no involvement in deciding fines, but the police officer has to interact with a member of the public. And that interaction is, by definition, can be confrontational, particularly if you're at the point where a fixed penalty notice is likely to be issued. And therefore, that makes that job, I think, considerably harder, where you're talking about a situation there where, as you say, in the sort of maximum point there, you could have someone looking at potentially £6,400 as a fine. And I recall particularly some of the fines for groups of people getting together, and this particularly I remember examples in relation to students when we were having a number of issues where groups of students were gathering, and you were having students, and some of the fines there were in the tens of thousands of pounds and so therefore, from a policing perspective, it's the practical application of the work that the officers were having to do against a backdrop of what seemed to be ever increasing numbers.
Was there any difficulty caused to you as the NPCC in relation to operational briefings or the guidance that you could give to police forces?
Well, our operational briefings would have to reflect the change. So that, of course, becomes then quite confusing for the officers, that this is now changing again. And of course, what you then get into is, particularly as we progressed through the pandemic, where there were, well over 100 changes of one description or another, that then, I think, inevitably leads you to where regulations or actions are misapplied because the individual officer, because bearing in mind these officers are doing what the police are doing all the time, which is policing 24/7 and dealing with all the other things they're dealing with, that's, I think, where you could get mistakes because of the kind of frequency and the speed with which we were having to put new operational briefings that are saying this has now changed. And
we'll certainly pick up that point in just a moment. But just before we do, the final point on fines. Is it right that the numbers of fines issued for test, trace and isolate related offences specifically were relatively low during the pandemic? 184 in England and 84 in Wales. Extremely low. And what, in your view, are the reasons for the low numbers of fines that were issued?
I think 2 points really. One, the sort of complexity and the continuing changing nature of the regulation. But from a policing point of view, a very specific challenge was for the police to take action. We can only take action against the legislation. So the officers can only act in accordance with the law. And if we are going to act in accordance with the law, you need to have the evidence trail that allows you to take the action that you take. And one of the challenges with test and trace throughout was that I don't think we were ever in a situation where the continuity of all of the evidence was such that it would allow a police officer to take an action in relation to a regulation. There were just too many inconsistencies. And as it says in the statement, this was an area where we had frequent engagements and meetings with the Department of Health and Social Care, but the system never got itself into a place where you could definitively be confident of it is that person with that test and positive test and so on. And so therefore, I think that's what led to that very small number of sanctions.
That's helpful. I'd like to actually ask you a bit more about the challenges police officers on the ground particularly faced in relation to enforcement. You've mentioned the number of changes made to COVID regulations. What sort of challenges specifically did that, for example, cause to the police officers on the ground?
Well, so apart from anything else, police officers are normal people. And also the other thing that I think was unique, I mean, I have been involved in a lot of critical incidents, but the unique thing about this incident is even though the police officers were there acting as police officers in a professional capacity, they were still being affected by COVID-19 in the same way that everybody else was affected. So it was really challenging for them as individuals to be keeping up with the changes to regulations, that we were then having to find a way to communicate in an understandable fashion through our briefings to allow the officers then to go and undertake the explain element of their role when they were engaging with a member of the public. We often got the new regulations with very limited time before they actually were enacted. The worst example, I think, was a regulation that was due to be enacted at a minute past midnight, and we got the signed off regulation from the Secretary of State at 1:45 midnight. And in that instance, we then still had a period of time, and depending on the number of changes and the complexity, it could take us, certainly hours and sometimes days to actually arrive at a briefing, an operational briefing that we were satisfied with. It would be pulled together by the College of Policing. It would go through their legal teams. It would then go through our legal teams. It would then be signed off at the college and then signed off ultimately by me. So that process was often slow and often meant that we were then behind the cycle for when the regulation came in, because what would happen at that stage is you would then get whoever the government minister speaking on that day would be talking about this new regulation, and of course confusion for our officers thinking, well, we have not had the operational briefing yet. So then that rolls into being able to explain that to the public as well. So I think that was one of the challenges. And then of course you then got the situation where as the pandemic progressed, we would have different regulations in play in the same space of land, not unusual after we started to get the localized regulations, the localized lockdowns within the same police area, or indeed in some cases in the same city or town, you would have different regulations in play. And what that led to was a real challenge. We worked very closely with the scientists, with the SPI B scientists throughout. And one of the phenomena that we talked with them about, because this was about how do you get compliance, how do you get maximum people complying with the regulations without having to be forced. And the concept there around othering was one that the scientists really brought out for us. And so therefore it's really difficult for the police officer when you're engaging with someone who is breaching a regulation and they know that the person 3 streets over there or the person in a different part of the country is not under this regulation. That then again raises the level of potential confrontation in that engagement, which then makes it more difficult for the police officers.
And did government guidance assist you at all?
Sometimes government side guidance hindered, if I'm perfectly honest. And one of the challenges was that when government would go out and talk in the media, the minister would offer, or the spokesperson, but normally a minister, would often confuse legislation, so regulation or legislation, and guidance. And that would confuse the public, because the public would then think that, well, it's unlawful to do that thing or not that thing, or vice versa. So that became a real challenge for us as well. And indeed, I would often have to do a media round to try and basically clarify that what the person said this morning is not part of the law. So that was a particular issue. And then the other issue around both the regulations, but definitely the guidance, was the lack of specificity in what was being said, and using phrases such as without reasonable cause. Well, what is reasonable to one person and to another? And there were a number of examples there, which then leads to confusion, legitimately leads to confusion in the mind of the member of the public. And then, of course, is hard for the officer to interpret. And then, of course, you then get back again into this confrontational scenario where the member of the public has rationalised that, you know, this is a reasonable cause, and then the police officer may feel otherwise, or we may have tried to find some clarity, but we were constantly going back at the process with the government to say we need to be clearer about what you're saying here. And you go back to the very early ones where you were allowed to, you know, for whatever the phrase was, necessary for shopping or going out and exercising. Well, it didn't say you could only go out and exercise once. You could go out 5 times potentially, or what was a necessity. And so all of that lack of specificity, I think, really caused us challenge.
And generally speaking, what was the response when you would take those concerns back to the government?
I mean, some. To be fair, we had a good working relationship with the government. My team that were running all of this for me had a very close working relationship with the team within the Home Office, and I spoke very, very, very regularly with the Home Secretary, with the Policing Minister, and we met, with other senior police leaders on a daily basis to assess where we were. So they would listen, but it inevitably got caught with the politics of what was going on and the pressure that they were feeling to act in particular ways.
Okay, now I'd like to ask you about one particular challenge relevant to test, trace and isolate, if I may, and that's in relation to the offence of failing to self-isolate. So is it right that in September 2020 it became an offence in England for someone who tested positive to fail to self-isolate?
Correct, yes.
And I think in around November that year, Wales followed suit and there was a similar offence in Wales.
That's my understanding, yes.
Now, could I please put on screen 99806? These are the minutes of a meeting of the Independent Ethics Committee about whom we heard earlier.
Yes.
And we can see underneath the heading Operation Tala Independent Ethics Committee the date, 5th of October 2020. Mm-hmm. And so that meeting took place after it became an offence in England to self-isolate, but before it became an offence in Wales. Mm-hmm. So if we could turn, please, to page 2. We see at the bottom of the page a heading Self-Isolation Regulations.
Yeah.
And so this is the section of the meeting where the new self-isolation regulations were to be discussed. And now if we can turn, please, to page 3. And we see that the committee was discussing, if I start with, yes, thank you, the section included some difficulties encountered by Tala/NPCC as a result of not seeing any draft legislation for the self-isolation regulations, and therefore the inability to influence key factors which policing would have to navigate as a result. And so just pausing there, do you recall when you first became aware that self-isolation was to become a criminal offence?
I don't recall off the top of my head. I don't recall that, but I do recognise that this appeared, and we hadn't had the opportunity to be involved in that at the earlier stage. That's definitely true.
Then the committee minutes go on to say a practical example of the missing data sharing agreement was provided, which would enable information regarding those that should be self-isolating to be shared to police forces and implement processes so that it was understood. Now, could you just break that down for us? What was the missing data sharing agreement? What were they referring to?
So the concept that we came up with was to try and agree a sort of memorandum of understanding with the Department of Health and Social Care in relation to how we could get, it goes back to the point that I made earlier in general terms about test, trace and isolate. It was about us being in a position to have data of sufficient quality that allows us to potentially identify that an offence had been committed, and we were never able to. So we tried to pull together an MOU with the Department of Health and Social Care to try and agree how this would work. But I think the data quality issues that persisted throughout meant that we never got to the point where we could deploy that MOU. And I suspect also that is part of what led to the numbers, the small numbers that we've already referred to in relation to test, trace, isolate.
So if I may, I'll just break your answer down a little, just so that we understand. The missing data to which you refer, or the problems with data, is that data as to whether somebody had tested positive, and so that element of the offence, or whether someone had failed to isolate?
Yeah, I mean, primarily it's linking the positive test definitively with the individual definitively, and then of course, then you need to add the data of where that person is. But it was really all about making sure that the system was the data quality in the system, and linking the different pieces of, or the different pots of data, to come to the conclusion that we would need if we were going to do something which is effectively taking a kind of legal course of action.
And we see then in the remainder of that paragraph, the committee say, whilst these details were worked through, this led to frontline officers and staff unable to enforce the legislation even after the legislation was passed in law. So I think that reflects what you've just told us. Yeah. And if we turn then, please, to page 3 of this document. And we go right to the bottom paragraph, starting, the chair provided a summary, which neatly encapsulates the conclusions of this meeting. The chair provided a summary that the committee felt was consistent to the discussion, in that to maintain public trust and ensure the correct legal basis for enforcement, police should not enforce the legislation until memoranda of understanding and data sharing agreement were in place. So was it the case that you, in fact, provided guidance or advice to the police forces that police officers should not enforce this legislation until such time as you had a data sharing agreement?
We needed to be in a position where we were absolutely confident that we had, we had the the evidence provided in the way that we would need if we were going to take that action.
And did you, in fact, then? You've touched on this, but did you in fact reach a data sharing agreement with the government? We
didn't. That MOU never came into full being.
So during the period of the pandemic, was the offence of failing to self-isolate enforced by police forces?
I think there were, I don't know the exact numbers off the top of my head, but I think there was some, but it really was the challenge of being satisfied that you have got all of the data necessary to actually take action.
Thank you. Now we can take that off screen. Thank you. The final set of questions I'd like to ask you, please, under the topic of challenges to policing, is in relation to how these challenges may have impacted the charging of offences at court. I think you're aware that the Crown Prosecution Service, the CPS, conducted a review into all COVID-19 offences that made their way to court. That review took place between April 2020 and March 2022. It was an ongoing review, is that right?
As far as that's what my memory of it, yes.
So could we look at the results of that review, please? INQ 587469. Thank you. Now, this is a bar chart illustrating the results of the CPS review. If we just look at it together, we could see that there are 6 bars on the screen.
Yeah.
And the first 3, if you see underneath them, is the label Health Protection CR Regulations. So those 3 represent cases charged under the regulations.
Yes.
And then the final 3 bars, the wording underneath them is Coronavirus Act. So can you see that those represent cases charged under the Act?
Yes.
And the Y-axis on the left shows the percentage of legal cases represented by the bars. And then the bars are in 2 colours. Blue represents cases correctly charged.
Yeah.
And can you see that orange represents the cases that are incorrectly charged? So if we turn first, in fact, to the last 3 bars, the 3 orange bars, cases charged under the Coronavirus Act, And specifically, could I ask you please to look at the first of the 3 orange bars, which is cases charged by the police under the Coronavirus Act.
Yeah.
Can you see that?
Yes.
And can you see that of 298 cases charged by police under the Act, all 298 were found to have been incorrectly charged?
Yes.
And in fact, in fairness to you and the police, in looking over to the next bar, those cases charged by the CPS under the Act, we can see that all 13 cases they charged were also incorrectly charged.
Yes.
Now, first of all, the Crown Prosecution Service have indicated in written evidence to the inquiry that the reason for these results was that prosecutors and police were incorrectly charging offences under the Act when they should have been charged under the regulations. In other words, they were offences enacted by regulations rather than the Act. Would you agree with that explanation?
I would, yes.
And in your view, what are the reasons or reason for that error?
Well, I mean, in the first instance, I think the Act, the nature of the legislation in the Act was incredibly imprecise and very difficult to imagine how that could have been used effectively in an operational sense by a police officer with the expectation of what that police officer would have been identifying in the person. I think also you then had that this was at the very outset, obviously, when the legislation was first passed and the pandemic commenced. And I think there will have been confusion then inevitably. And that probably led to that. And then equally, when officers were dealing with things later, they will have made the mistake to, as you say, to charge under the Act as opposed to charging under one of the regulations. But I think all of this was a symptom of the fact that, A, the thing was moving very quickly. There were lots of changes being made in a very rapid way, and that we were, sitting at MPCC, were trying our best to deliver that information through the operational briefings out to officers to allow them to act. But it was a confusing landscape, and I suspect that's largely the reason where officers have made the mistakes that are evident there on the screen.
Now, if we turn to the first bar in the chart, please, it represents cases charged by police under the regulations. And there we can see I make it a total of 2,514 cases in total. And of those, 520 are represented by orange, so 520 were charged incorrectly. Mm-hmm. And can you see that represents about 20%
Yes.
of all cases charged under the regulations?
Yes.
Now, the CPS themselves haven't offered an explanation as to those errors. His Majesty's Courts and Tribunal Service offered a written explanation in evidence to the inquiry for that. We don't need to put it on screen, but if I may read the explanation to you and see whether you agree. They listed the following as reasons why these errors were made. 1, the wording of the charge didn't match the offence in the regulations. 2, the evidence didn't match the charge. 3, there were charges of non-existent offences. 4, prosecutions under the regulations which hadn't been specified, so it was the CPS's duty to bring those charges rather than the police. Mm-hmm. 5, prosecutions for conduct which did not amount to a criminal offence on the date it was committed, but which was subsequently criminalised, so charging offences before the day that the regulations came into force. And finally, prosecutions under the Welsh regulations in England and the English regulations in Wales. Do you agree with those explanations for the errors that we see?
Well, they certainly sound to me like reasonable explanations. I mean, the one, I think it was the second or the third one that would trouble me was there wasn't the evidence. But for the others, I can see, and I think they demonstrate the complexity for the police officers on the ground trying to deal with a situation where the nature of the offences is changing quite as rapidly as it was changing. Which is, I know offences change all the time, but not in quite the way that we saw during that period. So I think some of that confusion is not surprising. I think where there wasn't evidence would be more concerning to me, but the others sound like credible reasons why this may be the case.
Were you aware at the time, so during the pandemic, of the errors in charging decisions?
We worked, obviously, as I said previously, our criminal justice, the criminal justice group under MPC were working very closely with CPS colleagues, as they do, and Crown Prosecution and HMCTS colleagues. So we would be aware as we were going through. But again, we have to take ourselves back to that period where, so this was as a result of a review, and we did a number of reviews as we were going along to try and understand, but we do have to go back to the situation at the time where this was fast moving, it was constantly changing, and the officers were having to try and deal with all of this, as well as, particularly once the initial lockdown, you're back dealing again with all the other normal, policing issues that you have to deal with.
Can you help us at all with any measures the NPCC took in order to try and address the errors? For example, training or guidance or anything like that?
So we were constantly learning throughout the process, and we ran a series of knowledge sharing exercises. So as and when we identified an issue, that would go out through, not necessarily through the operational briefings that would go out in relation to a particular regulation, but we would put all colleague calls going out from chief constables. So whenever we identified an issue that we were seeing starting to be persistent, we would share that across the forces, and then ultimately it was then for the forces to be disseminating that through their own processes. But there was a constant process of trying to learn as we went along and rectify where there were mistakes. But that, as I say, was running in parallel with this constant shifting of changing where the regulations were going to be, what was going to be happening, and then all the issues that we faced, clearly, because we were doing this in 4 countries. And at some points in time, all 4 countries were working under different regulatory frameworks.
Thank you. Now, just the final, if I can call it large topic, I'd like to turn to, please, is that of inequalities and equalities during the pandemic. I'm right, aren't I, that you commissioned, as the NPCC, an independent assessment, an external expert review of your own decision-making through the pandemic?
Yes.
And is it right that led to 2 reports? The first looked at a short period of time between 27th of March 2020 and the 25th of May 2020? That's
correct.
And that report was published on the 27th of July 2020 on your website. Mm-hmm. Now, you were asked about that report in some detail when you last gave evidence.
Yes.
And in fact, it's not my intention to go through that report in some detail. But there was a second report, wasn't there? And
yes.
That second report reflected a significantly longer period between the 27th of March 2020 and the 31st of May 2021.
Yes, that's correct.
Right? And effectively, then, it engulfed the period of time considered by the first report and went further.
The reason we commissioned the second one was because the first one was done by effectively government statisticians, which we wanted to get the information. We then saw that report and then wanted to get a longer and a more independent report that was led by a group of academics to just allow us to understand. Because after the first report, we obviously took the learning from that first report, as you rightly say, it was published, and that was then shared with all the forces so that individually forces could look at not only the overall findings of the report, but then those that were specific to their own force area to identify any issues that were particularly prevalent there. But then we wanted to get that independent academic review of the longer period to see whether some of the themes that we had seen in the first had persisted through into the thereafter.
And in fact, let's have a look then at that report together. So if we can please put up 87, that's the front page of the report on the screen now. So the report was called Policing the Pandemic in England and Wales. And we can see there the dates, 27th of March 2020 to 31st of May 2021. If we could turn please to page 12. And under the heading ethnicity, if we turn please to the second bullet point, can you see that it says over a quarter, 27% of FPN, so fixed penalty notice, recipients in England were from an ethnic minority background, which was around double their population share, 13.7%. And then it goes on to discuss Wales. The equivalent figure for Wales was 1 in 10, 10.7%, which was also double their population share. And then the fourth bullet point down, please. The ethnic disparity rate in England was highest for people from a black ethnic background, who were 3.2 times more likely to be issued with a fixed penalty notice than those from a white background. And the equivalent figure for Wales was 2.9. So we see from this page, don't we, that ethnic minorities were disproportionately more likely to receive fixed penalty notices. Then if we can look, please, at page 15. And if we turn to, the seventh bullet point, so it starts, fixed penalty notices issued to people from an ethnic minority background were more likely to be cancelled, 5.9%, than those for white recipients, with people from a black ethnic background being most likely to have a fine cancelled. So effectively, that means that people from an ethnic minority background were more likely to be found to have been wrongly issued a fixed penalty notice. Is that right?
That's correct, yeah.
And if we can turn to page 60 then, please. And we can see, oh, thank you. Under the heading cancelled or withdrawn fixed penalty notices, in the last three lines of the first paragraph, in the majority of cases, the cancellation or withdrawal of fines, it's been highlighted for you, was due to lack of or incorrect information provided on the actual ticket, lack of sufficient evidence an offence had been committed, or failure of officers to follow the 4 E's. Just pausing there, where officers failed to follow the 4 E's, what did that look like in practice?
Well, I suspect what that is referring to is that rather than going through the first 3 E's, the officers have pretty much reverted immediately into the issuing of a fixed penalty ticket. That is how I understood that that conclusion.
Thank you. And then page 65, the paragraph starting, the higher prevalence, at the top paragraph, starting the higher prevalence of cancellation amongst fixed penalty notice recipients from ethnic minority backgrounds was not simply because fines were issued at a higher overall rate for these groups. These findings indicate there was a genuinely higher likelihood that ethnic minority FPN recipients, in particular those from a black background, would have a fine cancelled regardless of how many were issued. So we can't explain the cancellation rate simply because there were more fixed penalty notices for ethnic minorities. Thank you. So, and then finally, on this point, page 76, please. And we're looking then at it's the second full paragraph, the third paragraph down, starting ethnic disproportionality within England and Wales is not uncommon, especially in relation to street-based policing practices. Therefore, given the significant focus on public policing during the pandemic, it might reasonably have been expected some ethnic disproportionality would have occurred. And then it goes on to say, research with police officers has suggested that those from minority ethnic backgrounds were not necessarily more likely to break the rules, but may have been more likely to do so in circumstances that make them visible to the police and thus available for intervention. Could I just ask you, what does the phrase "more likely to do so in circumstances that make them visible to the police and thus available for intervention" mean? Are you able to help us with?
Well, I think that I'm guessing that means out and about on the street, and out and about, in places where the police are going to, are obviously going to come across them. I think, and I suspect that, and I don't know. I mean, I wasn't one of the people in that research group, but I suspect some of that was is that point that people will have broken rules quietly and other people will not have broken rules more overtly. And I think particularly once we started getting into the area during the pandemic, which was in relation to the sort of, the unauthorised music gatherings and so on, I suspect that's probably what that is referring to. But I can't say for certain. I don't know exactly where that information came from.
Okay. Are you able to offer a view on the reasons for the disproportionate enforcement that in relation to ethnic minorities that we've seen?
Well, I mean, look, I have spent decades in policing where the issue of the disproportionality in policing with minority communities, and particularly with black communities, has been a key feature and a key feature of concern. That was why we instigated both of these reports. I was concerned about this from the outset of the pandemic. If, as I did, accepted that this issue was an issue that was prevalent and had been prevalent for many, many years in policing, and particularly in some areas, but generally speaking, an issue, it was absolutely clear to me that going into a pandemic scenario where we were in highly unusual policing, where we were dealing with highly unusual restrictions on people's movements and behaviour, that was going to be a concern. And that was precisely why, from the very outset, we instigated the first report, the statisticians' report that you referred to, and then why we initiated the academic report, the McVie report that's on the screen at the moment, to get that broader perspective into what was actually going on, giving some views on some of the reasons behind that, and then also allowing us then to be able to try and deal with those situations going forward. Because the other thing that we have to bear in mind as well is in the middle of the pandemic, in the period from the sort of summer point in 2020, after we had everything that followed the murder of George Floyd in Minneapolis and the subsequent Black Lives Matter issues, and then that put the whole policing context, which was already a challenging policing context, into a really stark focus. So this was an area that I was very conscious of. It's an area that I have always had concern about in all the things I've done in policing, and that's why we commissioned these reports to understand.
Thank you. We can take that document off screen. Thank you. Just one very small and final point in relation to inequalities before we conclude. It was found in the report, wasn't it, that, and I'll just read this section out to you from page 14 of the report. Repeat fixed penalty notice recipients in England were 1.7 times more likely than single recipients to be living in one of the top 10% deprived, they've used the term LOSAs, but effectively areas.
Yeah.
In Wales, the difference was narrower at 1.3, but still statistically significant. So is it right that effectively those who received fixed penalty notices were far more likely to be living in areas that were ranked as deprived?
Sorry, did you? Yeah, I know. I would agree. I would agree with that. And look, the simple reality is, if you take it from the beginning, with all the various restrictions, everybody in the UK did not experience the same COVID restrictions, because if you live in a large house with private open spaces and lots of room, then that you had one experience when you were locked down in COVID. If you lived in a small flat, in a block of flats with no private open spaces, you lived in a very different COVID experience. And I think that is something that was always a concern from our perspective, because clearly what that then does is put certain people into a much more likely to be in a position where they are, in one way or another, either deliberately or with, quite frankly, no option, breaching a regulation. And I think that point that came through from that report was not one that surprised me at all. And I think that needs to be, really carefully considered when you're thinking about what a restriction means to individuals rather than a sort of mass group.
Thank you. And then just finally, again, you've previously set out lessons to be learned and recommendations for us at the inquiry. You've had time to reflect. Are there any other specific lessons or anything you'd wish to add to those that you've already given us?
No, I mean, I guess in a sense it's probably reinforcement that, and I've made the point a number of times, it's first of all, were we in a similar situation again, it's not seeing this as an enforcement exercise. It's an exercise as to how collectively people can, be brought to a place where they are respecting what needs to be done to prevent the further infection rates. The clarity of legislation, and I get that this was happening at speed, but it had been moving for quite a while towards the UK. So I think really clarity about the legislation, and within legislation, specificity about things that were not allowed, things that were allowed. Similarly, the point about the difference between a law and guidance being absolutely clear in the way that things are communicated, because that's caused a great deal of confusion to people. And then I think from a purely policing point of view, finding a mechanism to be involved at an earlier stage in getting to the detail of what the different regulations would be, I think would be helpful. We had a good working relationship with the Home Office. We were able, but of course, the Home Office were working with us vicariously. Most of this was happening in the Department of Health and Social Care, where we struggled to get the relationships that we wanted there because we were to some extent kept on the outside. So I think how you bring the whole system together and that specificity and really clarity of message is what will allow people to comply more readily and more easily.
Thank you, Mr. Hewitt. My lady, those were all my questions.
Thank you very much, Mr. Mr. Dale. Are you asking the questions today?
I am indeed.
Mr. Hewitt, can you hear Mr. Dale? Would like to say something?
Not if he's speaking now, but
No.
Can you hear me? Are you able to hear me?
I can hear you now. Mr. Dale.
Very well, thank you. Thank you, my lady. And Mr. Hewitt, I ask questions on behalf of the Federation of Ethnic Minority Healthcare Organizations, or FEMO. And I have a few questions. So you refer to the NPCC liaising with government in relation to various policing issues. Firstly, can I invite your comment on an issue broadly? Did the NPCC ever liaise with government about the potential unequal impact of new COVID legislation and particularly enforcement on ethnic minority groups?
Yes. So yes, we did, and as I said earlier, I had very regular meetings with the Home Secretary and with the Policing Minister, and I raised, as did they, to be fair, from the very beginning, because I go back to what I just said, which is I entered the pandemic, or my role in the pandemic, I entered in the full knowledge of the challenge that policing has in its relationship with minority communities, and particularly the black community. And so therefore we were very attuned to that, and that was something that I was constantly liaising with government and with at official level, but also at ministerial level, and hence why we commissioned the two reports that have just been referred to by council.
Thank you for that. And can I get a little bit more granular and invite your comments on some rather more specific scenarios? Was any particular consideration given to young people and or people from ethnic minority groups where English was not their first language and who might have been less able to articulate a reasonable excuse they had to leave their house, for example?
Yes, I mean, I was very concerned again at the outset about the impact on young people on a whole different range of levels, but particularly, you know, I think in the first lockdown it was pretty much comprehensive, but as the lockdown started to be gradually released, I was very focused on young people because I would recognise that young people would be much more inclined to want to be out and doing the things they would do normally. So we did focus around that, and our NPCC lead for youth was very engaged around that. Your point about language is absolutely key. And of course, in certain communities, there will be a whole range of languages. So that was really about focusing in that, as I've already said, the engage and the explain point was really expecting the officers to take the time to explain to someone who might not immediately, you know, be able to understand the regulation and what that requirement means. And that was really what we were trying to achieve with the approach we were taking about, you know, engaging and then explaining and then trying to encourage the person to follow whatever that particular regulation was.
Can you say how the perception of and trust in policing might have impacted on the response of the individual start?
Yes, I think it absolutely would impact, and that really was the point that I was making, because we started the pandemic with the challenges that I've referred to in the relationship between policing and minority, but particularly the black community. That is inevitably going to impact any engagement and any encounter. You know, the work that everybody will be familiar with around stop and search more generally. So this is an encounter between a police officer and a black member of the public, particularly if it's a younger black person. So we were very alive to the fact that engagement will already start with, if you like, the history that is there in the minds of both the police officer and the young person or the individual.
Very well. And can I invite your comment on another issue that you might have been alive to? The fact that those from ethnic minority households would be more visible to police, as statistically they were less likely to have had private space available to them and were therefore more likely to socialize outside of their homes.
Yeah, I think, and I think I sort of alluded to that in my answer to the last question around the deprivation indicator. I think that it is a fact that in lots of the communities that are the, if you like, the most deprived communities, there will be a high incidence of minority communities there, and therefore the fact, as I just said there, if you are in a building where you do not have private open space, where you do not have, you know, a lot of ability to do, you know, to have to live in the COVID under the restricted, then that is going to mean that people are going to want to be able to get outside and you know, and go outside, and then of course, as you allude, then that therefore means that they are out there, you know, in the public space in a way that perhaps others would not have had to have that necessity to do that, and therefore that then leads to the engagement and the encounter, and potentially, obviously, some enforcement if that's where that leads.
Yes, and finally, can you say whether there were any steps to assess, address, or mitigate the foreseeable impact that you speak of race discrimination when COVID regulations were made?
So the police service always operates under the guidance that it does and the way that we have to deal with all communities. But I think what we did, we were very, and in where we were talking and in all the meetings that we were holding and in all the information that we were putting out, it was very, very clear we needed to be doing this in exactly the same standard that we would do anything, and we needed to be absolutely clear around that. But it was also talking in the sense of understanding that for some communities that was going to be a more challenging, the COVID with any communities was highly unusual and out of the ordinary. But where we started with communities, and in that case, I would say certainly particularly black communities, we knew that we started in a position where the police community relationships were not where we would want them to be. So there was a real focus around that. As I say, policing was delivered by the police forces. So in every police force area, there will always be the community working that's going on there, and they will know their communities. So there was clearly a reliance around that. But also in terms of learning and going forward, which was really important for me as well. One of the things that not directly COVID related, that I instigated in the summer of 2020 was, and it still exists now and is a full-time program, is the Police Race Action Plan program that I started in the position that I was in at that point, which then brought all forces together and the communities together to look at all of the issues that we have in relation to police and black minority community relations, but particularly was using the evidence and the further evidence that we were getting from what we were seeing, as we've just seen through the reports during the COVID period.
Thank you. Thank you, my lady.
Thank you, Mr. Dale. Mr. Hewitt, that completes the questions we have for you. Did somebody tell me you've got a flight to catch?
I'm just about to in about half an hour's time. So
Well, we would never have
flying in
guessed.
half an hour, but
Oh, we'd never have guessed that you were in a rush. Thank you very much for your help and for your very measured and sensible responses. Thank you again for contributing to the inquiry.
thank you, my lady. Thank you.
Very well, I shall return at 22. It's nice.
My lady, can the next witness, Dr. Emran Mian, please be affirmed?
If you can repeat after me, please. I do solemnly,
I do solemnly,
sincerely and truly
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Dr. Mian, I hope you were warned you'd be last on today.
I have been, yes, thank you.
Thank you. Can you confirm your name, please?
Yes, my name is Imran Mian.
And Dr. Mian, you've provided a witness statement dated the 17th of April 2025. You have a copy with it and familiar with it.
Yes,
Page 31 is your signature and statement of truth. Can you please confirm the contents of it are true to the best of your knowledge and belief?
yes, I can confirm.
Thank you for attending today and assisting the inquiry. By way of your professional background, can you also please confirm that you are a former senior responsible officer for disproportionately impacted groups, a position you held between August 2020 and December 2021, and it's this role you'll be giving evidence about today.
Yes,
Between 2020 and July 2023, you were Director General for Decentralisation and Local Growth at the Department of Levelling Up Housing and Communities, now the Ministry of Housing, Communities and Local Government.
yes, that's right.
And you are currently Director General for Digital Technologies and Telecoms at the Department for Science, Innovation and Technology.
Yes,
And in relation to that role, you provided a statement for Module 4, which was dated the 30th of July 2024, but that statement is not relevant for the purposes of today.
understood.
Thank you. Thank you very much for your very helpful statement. What I'd like to do today is begin briefly with the context of your appointment as SRO and then look at the work of the group and your recommendations. Just in terms of the context, you were appointed in August 2020, and it's right that at that time, over the spring and summer, PHE and other bodies had already been reporting on the unequal impact of the pandemic. COVID mortality rates significantly higher for minority ethnic groups who are also more likely to work in occupations with higher risk of exposure to COVID. And the numbers were higher for older people and disabled people, and that was established by then. Are you able to comment on why your appointment was only made towards the end of August and not earlier?
As to why it was not earlier, I'm afraid I'm not really able to comment. I think what I was noticing and some other colleagues, civil service colleagues were noticing, was that there was a gap in this space, and that while we had the data reports that Public Health England had produced, we hadn't then proceeded to take specific policy actions or even take propositions to ministers about specific policy actions other than in relation to the shielding of clinically vulnerable individuals. And so kind of my view was that we did need to start taking such propositions to ministers. That was a view that other colleagues held as well. And so from my recollection, it was in the run-up to a Cabinet Secretary chaired meeting of officials that I then, well, slightly volunteered, was slightly asked to play this role, in addition to the role that I was already playing in MHCLG itself.
Okay, thank you. That's very helpful. And in terms of the language and the term disproportionately impacted groups, shortened to DIGS, I think.
Yes.
Conceptually, that's a term that allows quite a wide lens. Is that why it was adopted?
Yes, that's right. Yeah. I think while quite a lot of both the evidence at that point and some of the public discourse focused on either disabled people or people from minority ethnic backgrounds, I think kind of my view and sort of our view was that we needed to look at this set of issues. There would be benefit in looking at this set of issues together. And that's why we sort of landed on this way of thinking about it as a set of disproportionately impacted groups.
And so as a term, would you recommend that as a term going forward because it allows that wide lens?
Yes, I think that's the benefit of it.
And just on that also, would you agree that it's probably preferable to other terms such as hard to reach, which tends to turn the problem on those who are impacted rather than the gaps in policies, for example?
Yes, I think that's right.
Great, thank you. Just briefly then again, in terms of the formalities of the group, you didn't have a dedicated team, so you were drawing on people in the COVID-19 task force, and the relevant minister was Kemi Badenoch, is that right?
I was drawing on team members from the COVID task force, that's right. I think ministerially, I would say that it was a combination of the minister who was responsible for equality, so Kemi Badenoch, but then also in some sense, because the propositions we were taking from ministers to make decisions were to the COVID-O, it was the chair of the COVID-O who in a sense was the other sort of key ministerial customer.
Mm-hmm. Okay, thank you. Okay. All right, turning then to the work of the group, your witness statement explains that you commissioned all departments to provide recommendations, and you then proposed a paper, you then drafted a paper on the proposed remit. Can we look, please, at INQ 90046? This is the September preparatory paper. Just page 1, please. Paragraph 1 deals with the context that we've just identified and the statistics and data that's applicable. And you see at the end, urgent action needed to prevent the same issues being replicated that we're facing in the second wave of infections. If we can move down to paragraph 2, please. And the second sentence shows that young people, women, ethnic minorities, single parents, disproportionately likely to suffer long-term adverse impacts from the measures taken to control COVID. And it then goes on that government data shows ethnic minorities issued with fixed penalty notices at a rate of 1.6 times higher than white people. We must recognise that as police engagement and enforcement will often be directed towards the most impacted communities, there may be a disproportionate impact on those groups. We know, though, from an email, which we don't need to see, but an email confirming that the Secretary of State wanted to keep this separate from enforcement because it had a different focus. And it was deemed a much more public health education set of interventions than compliance interventions. That's correct, isn't it? And
Yes, though I think the context of that email was different. The context of that email was there was a proposal before COVID-0 around improving enforcement of social distancing rules.
Okay.
And equally, there was a proposal in front of COVID-0 around appointing community champions. And they were quite different proposals in nature. And so the reason, that was the view I was expressing in that email, and that was the view that I had discussed with the Secretary of State at that time for MHCLG.
I see, but the focus of the DIGS work was away from enforcement and on health interventions.
That's right.
Yeah, okay, thank you. Okay. The paper then goes on to set out some proposals in relation to health interventions to reduce mortality and transmission. And we have the minutes and decisions of the September meeting fully set out in your statement. And they focused on improving communications and data gathering, this is for the purposes of TTI, and improving trust in NHS test and trace. Can I just ask, for the benefit of anybody following, the importance of trust in NHS test and trace is because greater take-up leads to greater numbers of tests, people isolating, and that then leads to lower transmission. And the focus on data at that point, I pause there to say the inquiry's heard a lot about data, but in this context, would it be right to say there were two focuses? One, gathering data on who was impacted and who formed the disproportionately impacted groups, and secondly, then data to track the progress of interventions.
That's right.
Okay, that's helpful. So moving on then to October, please. Can we have INQ 531409? In your statement, you explained that the Prime Minister had invited more ambitious proposals. And this is an email that you sent on the 8th of October to various officials involved in the group. And we see in paragraph 1 reference to the steep rises of COVID and the numbers of ethnic minority groups affected. Then down to the second paragraph, the Prime Minister asking for a more ambitious approach, demonstrating greater ambition. And then down again, please, you're noting there that the proposals so far had not been specific enough. Can I ask, please, that we focus on the second and third bullet of that email? Thank you. These are suggestions, I think, that you were making in that email about ways that the work could be taken forward. Is that right?
Yes, that's right. I mean, if I may, just to sort of provide a bit of context around that, I think what we were finding was, in terms of the specific proposals coming forward from departments, they were not at a high level of ambition to deal with the underlying issues. And I think that was for a combination of reasons. Some of it was due to simply lack of, there was lots of other things that people were having to focus on. I think people were struggling for funding to be able to pursue further interventions. And then I think there was also a widespread view that these are systemic health inequalities, and solving them in the middle of a pandemic is an incredibly challenging thing to do. And so what I was trying to do with this note and other notes like it and some of the discussions was to make some proposals to colleagues, and inevitably these were expert proposals because we were ranging across the work of many departments in many areas. But with the colleagues I was able to draw on from the task force, what we were trying to do was to seed some ideas with departments and see which of these ideas were ideas that departments then might be able to do something with. So it was one of the techniques we were using to try to elicit both a more specific set of proposals and a more ambitious set of proposals.
And can you help us with, in relation to the two that we have on the screen, anything further in terms of who fed into them, the impacts identified and the anticipated outcomes, bearing in mind the focus of this module is on testing, tracing and isolation?
Yeah, so in relation to the first bullet point that's highlighted, the second bullet point in the list, I think the reason for flagging this as an issue for further consideration was simply because We did, of course, have guidance already on self-isolation and shielding of clinically vulnerable individuals. But where they were living in multi-generational homes, you might have a child who's going to school and therefore at risk of exposure. You might have a working age adult who's going to a workplace where they're at risk of exposure. And so those isolation elements were not able to be as successful as if that person was sort of living on their own, as it were, or living in a household with only other people of the same generation where they'd be exposed to some of the same behavioral factors or same risks. So we were trying to think about what are the ways in which you can tackle that. And I think kind of, this would have been a very, very difficult thing to implement, and that's the way that it proved, because the immediate advice we got back is we do not have sources of alternative accommodation where you would take people who live in multi-generational homes and have them be care homes. Of course, didn't have capacity at that time. We didn't think there were other sources of alternative accommodation. In any event, even if I think we had located such, I think there would be some real challenges about implementing a policy like this. Some of the very same communities in which you might have a higher prevalence of multi-generational households, their willingness or desire to comply with a policy like this, even if the alternative accommodation was available, might be very low. And so we thought it was important to test those arguments, which is the reason for putting it in the email. But in the end, this didn't really go anywhere, I'm afraid.
So you're talking only there about the second bullet down, the first one that's highlighted, the multi-generational homes. Yeah, okay. And then in relation to the second highlighted bullet, supplementing self-isolation payments, can you talk more a little bit about that and what?
So again, trying to tackle the same problem, but just thinking about a sort of different approach to it. So rather than the government, as it were, whether central or local, providing the alternative accommodation, you provide an additional payment to the individual who then sources that accommodation themselves. But again, given the challenges we were facing during the pandemic, even in relation to private rented accommodation, the restrictions that were in place on hotels also, I think in the end we reached a very similar judgment that this didn't really pass the feasibility test.
And do you remember whether in relation to that proposal that was directed towards only people who were dealing immediately with a COVID infection and needing to isolate, or it was also intended to be directed to people suffering indirect difficulties, people living with violence at home and so on?
I think it was primarily in the context of this specific communication intended to cover the former, not the latter.
And so what happened with these two proposals, if you remember?
Neither of these departments gave us proposals that we could then take to COVIDO.
Okay, thank you. All right, thank you. If we can please go over the page. And can we please highlight the third and fourth bullets on that page? These are testing-related suggestions. And again, if you can help us with how the ideas were developed and what happened with them, that would be very helpful, please. The first one is the specific commitments in relation to boosting access to testing.
So this was, I think, responding to what was well understood at that time, that we were seeing higher prevalence among some disproportionately impacted groups. So we were trying to think about how do we sort of get ahead of that as well as best we can by having enhanced testing in place. I think in the end what we did was have boosted access to testing in specific parts of the country where there were higher rates, rather than with people of specific demographic characteristics.
So it was taken through by way of looking at numbers and then boosting access that way.
That's right.
And using the data.
Yeah.
Yeah, okay. And then in relation to the one below that, including ethnicity as a risk factor in the testing system, can you unpack that a little?
Yes, no, exactly the same thought. Where we're making decisions about where to focus testing infrastructure and testing capacity, should ethnicity be one of the factors that we're using to guide where in the country that goes? And I think in the end, the judgment we reached is you sort of, in one sense, don't have to use ethnicity. You can simply go by case rates. and focus your testing on the areas with higher case rates.
So was that focused on in-person testing as opposed to adding something to online booking?
I think that's right. I think, yes, the boosting will have been in relation to in-person testing.
And not ordering tests or anything like that?
I think that's right.
Okay. And can you help us again then? How far did those get in terms of reaching the next meeting and the approval thereafter?
I think those proposals were taken forward not via COVID-0 discussion on disproportionately impacted groups specifically, but in relation to COVID-0 discussions about the rollout of testing.
Okay, thank you. Thank you. That can come down now, please. Moving on then, please, to the late November, December meetings. These were focused on disability. And the preparatory paper recorded the urgency of addressing disability, noting the death rate from COVID of people with disability still much higher, and that disabled people are much more likely to be affected by the indirect impact of COVID, such as unemployment and financial instability. The recommendations are fairly extensive. They start at page 16 of your statement, and some of the recommendations were approved. Before I ask you about which those were, can I ask you, you've seen the statement of Cameron Malik made on behalf of the disabled people's organisations. And he makes a number of points in his statement about what he says are the deficiencies of TTI, which contributed to disproportionate numbers of deaths of disabled people. And those included lack of access to testing centres, digital exclusion, which is more likely to affect disabled people, and obviously relates to online booking and so on, inaccessible communications, and concerns about the adequacy of financial and practical support for people isolating, and that these issues were raised from about June onwards. Can you help us, please, with the degree to which those issues and TTI were addressed in that specific meeting? Or I should say in the meeting that was specifically focused on disability, if you recall.
Yeah, I mean, I hope as the kind of the summary of the conclusions from the meeting makes clear, we were trying to cover that set of issues. I think the categories we used were a little different to the categories in Mr. Malik's statement, but the categories are laid out on kind of in my witness statement, I think in paragraph 20. So we used a slightly different set of categories. But I think all of the issues that you went through were issues that we had proposals on, including, for example, helping disabled people access and use digital technology, providing support for the parents of disabled children. Now, I think while those were the actions that were agreed by COVID-0, in what followed, quite a few of these proposals were then not, in fact, taken forward through a combination of lack of funding for them, but also lack of capacity to implement them. So as an example, I think the proposals around ensuring more disabled young people have the technology that they need to, that was kind of put to DCMS as something that they might take forward. And my memory is that they weren't able to take that forward because they didn't have access to the funding that they would need to be able to take it forward.
But in relation then to, this is going backwards a couple of pages to page 16, the measures set out under reducing mortality and morbidity, there was regular testing proposed there. Would they, and then details regular testing in care homes and to care settings and support workers, I think. Were they taken forward by the group? I ask because the outcome says some of the recommendations were taken forward, but it's quite a concise note that came out of the meeting. So
yes, my recollection is these proposals, those specific proposals in that section of the paper were taken forward, and I note that all of them are listed where there's proposals that were unfunded. We say that in the paper. Each of these proposals, we not only state the lead department, which was DHSC, but we also say that they were funded.
All right, thank you. Is there anything else that you can add to help us on the way disability was approached by the group with a particular reference to TTI?
I don't think I've got more to add beyond what's in my statement on that issue.
No, that's fine, thank you. All right, moving on then. The work continued into 2021, and as you say in your statement, in January you invited a range of officials from across Whitehall to join a new steering group, and that was to progress existing programmes that drive forward action and accountability. The preparatory documents for that meeting stressed that the patterns of Wave 1 were being repeated in Wave 2 in terms of ethnic minority case rates and deaths, and that testing take-up was still lower in those communities. Is that fair?
That's right.
And those papers refer to future interventions as being community, workplace testing and further support for isolation. You note in your statement that by February you were concerned, leading up to the February meeting, that DIGS was not being adequately covered in existing work on the roadmap out of lockdown. That's paragraph 26 of your statement. Do you have any views as to why that was at that point? Because obviously by then we were 7 months after your appointment and the facts were well established by then.
Yeah, that's right. So look, I mean, I can unpack slightly the statement that I made then. It was that in the conversations that were beginning to take place around that roadmap and the agreement of the roadmap and the issues that needed to be tackled to make the roadmap a success, consideration of disproportionately impacted groups has sort of slightly dropped out of the picture again. And I think kind of both formally through this process and through a number of informal conversations, what I and other colleagues were trying to do was to look for the places where, as we implemented that roadmap, where did we need to bring back in consideration of disproportionately impacted groups. And this, I'm kind of, sadly was a little bit of a pattern as we moved through the different phases of the COVID response, is we would get to a better place in terms of people recognizing what the data told them and things that we ought to consider doing for disproportionately impacted groups. And then the pandemic would sort of, we'd move into a new phase of the pandemic and a new phase of the response, and partly because people were having to respond very quickly, but partly also because these issues were not getting the right systematic attention, we'd then slightly drop back down again in terms of our base of ensuring that these issues were being considered. And this was another one of those occasions where, excuse me, as we were looking at the roadmap, that had happened again. And so what we were trying to do here was to bring it back up into the order of prominence.
So do you just want to understand, do you mean that with the ebb and flow of the sort of intensity of work needed, that there was an ebb and flow of interest in addressing this issue?
Yes, I think that's right.
Yeah. Okay, thanks. All right, then after February, we move on to March. And can we please display 593765? And we'll go to slide 10, please. This was quite a substantial slide pack that was prepared for the March meeting, and this was a meeting that was considering place-based equalities and drawing attention to factors of deprivation as drivers of enduring transmission. So clearly by then a link was being made to the need to support people isolate and transmission. This is a slide on the right. One can see that the data showing that self-isolation on symptom onset is the most effective way of reducing the R number on the top right. Thank you. A 10% improvement in self-isolation, estimated to reduce R by somewhere between 7 and 11% overall. And then the graphs on the left, the top one showing people in low income brackets less likely to request a test. And the columns on the left correlate to never requesting a test. And then the bottom graph, people in low income brackets less likely to self-isolate when they've told they've been in contact with someone with symptoms. There's also a slide later on, this is slide 26, we can have it up on the screen, but that shows the link between financial insecurity and not downloading or using the contact tracing app. Can I ask, those can come down now, thank you. The slides note at the end that the lack of financial support and security for affected groups was resulting in non-compliance or non-adherence, and plainly that links to transmission. Was it agreed by that stage that lack of support was having a very pressing impact on the ability of disproportionately impacted groups to adhere to TTI?
Yeah, so I think the direct answer to that is yes. I think when I reflect on those slides, I think they were probably slightly overconfident in putting all of it down to financial insecurity. I think for individuals in those lower income groups, there's probably some other things going on as well about why they were engaging less. And some of that might be down to trust in terms of public authorities. There might be other factors too, but it might not just be financial insecurity. But I fundamentally don't quibble at all with your characterization of it. I think we understood, those charts showed that financial insecurity was a big part of what was going on here. Now, self-isolation payments were in effect at that point. We did then, I think, we then added a pot of funding that was given to local areas each time there were locally based restrictions, which allowed local areas then to do further targeting of financial support. I think from my recollection, that was the extent of the financial support measures that we took.
Do you remember whether the group at that stage discussed the success rate of people applying for the support grant? Because although the grant was available, the take-up numbers were relatively low.
I don't think we did discuss that at that particular meeting.
Okay. And do you think that there was an understanding that failure to support people to isolate was itself then having a disproportionate impact, so in a sense exacerbating the already then existing disproportionate impact?
Yes, and that's yes, no, and that was the reason for sort of that part of the slide pack, was to zero in on exactly that issue.
Mm-hmm. Okay. Can you help us with any reflections that you may have on why support for isolation was perhaps not seen as more pressing or urgent earlier on in relation to these groups?
I'm not certain how to answer that, or whether I should answer it now, but kind of one thing I've been reflecting on is, in terms of kind of the lessons learned, is kind of in my witness statement, I talk about some of those lessons learned. I think the thing that we didn't say at the time, but which I've reflected on since, is we didn't at any point have a pot of funding dedicated to funding interventions for disproportionately impacted groups. And so each time we were making a proposal for what to do to mitigate the impact on disproportionately impacted groups, we were not only trying to generate proposals, but in a sense those proposals were competing for funding against other things that needed to be done, both in relation to the pandemic, but also things that departments were doing in the other course of their business. And that was a kind of regular challenge and a regular trade-off that departments were having to make about funding. And I do wonder now whether, if at some point in the pandemic we had made the decision to have a pot of funding dedicated to interventions for disproportionately impacted groups, similar in a way to what we did do at the beginning about shielding and kind of providing specific support there, whether that would then have allowed us to more confidently develop proposals that help disproportionately impacted groups, and to know that we had a funding route for them. Whereas in fact, the way we did things, we sort of had two barriers that we had to get over. First, we had to be able to develop a proposal that was deliverable, and then we had to be able to identify funding for it.
Given what you say and the repeated issue of getting funding for proposals that had started at the beginning of the work in September or thereabouts, with the benefit of hindsight, can you reflect on why that suggestion wasn't perhaps brought forward or suggested by somebody in the group or a minister or so on before then or at any point?
I think some of it was simply due to there were so many things competing for funding at that time. I think that was probably a large part of it. I think another part of it was, and you'll see it in the structure of the papers where we talk about the lead department and whether it's a funded or non-funded proposal, is the classic way in which we do this in government is the accountability for delivery of something and the accountability for the funding is through the departmental line. And so the approach that I was describing would have been a very significant exception to that way of doing things. And you could call that a lack of imagination, but it was also simply due to the fact that sort of typically the way you do things is you run them through an individual department and then you have a clear line of accountability on delivery of that and the value for money of what's being done.
So bearing in mind then what you've just said, might it be a recommendation going forwards that it's something to consider at any rate, having a separate fund?
Yeah, and I think as part of considering it, then you'd want to be very clear on who holds the accountability for that money and for ensuring that that money is being well spent and is delivering value for money. So you would in the end, I think, have to pick a department and a Secretary of State who's accountable for that.
That's very helpful. Moving on then to recommendations. These start at page 28 of your statement. The last meeting was held on the 8th of December 2021 and you undertook a lessons learned exercise, and it's right to say that all the recommendations from the lessons learned document are faithfully reproduced in your statement. Can I ask first, how many people contributed to that exercise, whether by attending the meeting or contributing to the paper or thereafter?
I'm afraid I can't give you a precise count, but I think it would have been dozens of people. We did try and consult widely with colleagues who'd been involved in the work at any point. And that included colleagues across the range of departments, but also colleagues in Public Health England.
Thank you, that's helpful. It's important to reflect on what had gone well, and that included into having a dedicated team, the steering group, and you in a role that was clear and visible, so there was an obvious point of contact and knowledge on the issues as they arose. Is that fair?
I hope that's fair.
Is there anything to add by way of future recommendations?
No, I think apart from the one that I've talked about in terms of money, which we didn't land on in this list, but it's something I've reflected on since. I think the other one that I would really pull out is it was around the sort of the way we characterize it in our lessons learned was as a web of responsibility, where I think that's the recommendation I would really emphasize. Having a minister who feels accountable for this set of issues and for showing progress against this set of issues, having as senior an official as possible supporting that minister in doing that, and for that to be quite a formal role, potentially somebody's, the only thing that they're doing. Whereas as I observed right at the beginning of my testimony here today, I was doing this in addition to a full job, as it were. And the reason for stepping into doing it was that we didn't have this role. And I think that vacancy was holding us back. But I think what would have been even better is to have a senior official, possibly up to permanent secretary level, but it could be done at a different level, who is responsible for driving this work.
Because one of the identified lessons under what's not gone well was that there was insufficient focus on people from DIGS at the start of the pandemic response. And I think, as you've just reflected, limited remit and lack of ministerial interest or engagement, and that all ties together, does it, I think, with what you've just said?
Yes, and as you began by observing, we had some of the data about disproportionate impact starting from May onwards, but it was August, September before we properly had arrayed anything in terms of responding to that data.
So is what you're saying that by May this work could have been started, but either way, in terms of future recommendations, have someone in post at the beginning?
Yes.
Yeah, okay. Can I also just finally then ask on the recommendations, which are on page 29, you also refer to the importance of embedding equality considerations of disproportionate impact in crisis response from the outset of policy making and not retrofitting equalities impacts writing of PSEDs. And then an example of consistent impact reporting and all advice to ministers across Whitehall. In relation to equality impact assessments, generally and then specifically in relation to TTI, was it your impression or the impression of those feeding into the lessons learned that they were or had been retrofitted during the pandemic?
Yeah, I think too often the fairest characterisation to say would be the public sector equality duty considerations were coming at the back end of a policy-making process or a programme decision process, rather than being the set of considerations that was guiding the design of that right from the very beginning. There are exceptions to that, of course, such as the work on shielding. But I think it's still uncomfortably often that the public sector equality considerations come toward the back end of a process. And so that's what we were trying to draw out here.
And on that point, would it be fair to say that if it's done at the beginning, not only is the policy going to address those issues or potential problems from the outset, but if it's done visibly, you can bring people along with government decision making. You build trust and social cohesion in the way that the decisions are made.
Yes, I agree with that characterisation.
Okay, thank you. That brings me to the end of my questions. Is there anything else you would wish to add to your evidence about how the digs issues were or should have been addressed in relation to TTI in particular?
I don't have anything else to add.
Thank you. I have no further questions.
Thank you very much, Ms. Nice. Thank you very much indeed, Dr. Whelan, and thank you for trying to do what you did. There was obviously a gap and you did your very best to fill it, but I can imagine it wasn't easy.
Thank you.
Thank you for all that you did. I gather there's an application from Miss Cartwright, who's standing behind you, Miss Nice.
Please, my lady, I hope you can hear me. My lady, I make an
Oh, wait a minute, you need the microphone.
come forward. Lady, sorry to delay you, but very briefly, could I make an application, please, for a restriction order pursuant to Section 19(1)(b) of the Inquiries Act? My lady, it's simply to restrict publication in the transcript and from broadcast on any of the YouTube or on the website of essentially the last answer that was given to your wishing Mr. Hewitt well. It's simply the timing of 15:25:20 to 15:25:26. And my lady, I don't want to go into the Section 19(4)
And I know
grounds.
the detail. Thank you.
I'm very grateful. Thank you very much, my lady.
Application granted. Sorry, it's got nothing to do with your evidence, Dr. Flynn. It's an entirely different matter. Somebody was a little free with the information. Thank you very much indeed. That completes the evidence for today. 10 o'clock tomorrow.
Thank you, my lady. Good afternoon.